Thank you, counsel.
Thank you, Your Honor.
Mr. Yarger.
Thank you, Mr. Chief Justice, and may it please the Court. Rather than identify one federal rule that applied here, in fact collided with the Delaware statute, petitioner identifies seven separate rules and manufactures conflicts with all of them. All of those conflicts are entirely hypothetical. The trial court did not hold and respondents did not argue below that this case could not be commenced under Rule 3. Respondents never challenged the pleadings under Rule 12 or otherwise. Respondents didn't argue the affidavit had to be filed with the complaint under Rule 11 or disclosed in discovery under Rule 26. What this court held in Hanna is that trial courts in the federal system must enforce state laws using federal modes of enforcement, even though the federal rules are not identical to state court procedures. Here, the trial court held and respondents argued only that the Delaware Affidavit of Merit requirement had to be satisfied to maintain a cause of action for medical negligence under Delaware law, and because petitioner couldn't obtain that affidavit, this case had to be dismissed. The only question in dispute under Hanna is whether the Affidavit of Merit requirement can be enforced in federal court at all. It can. It can be enforced through dismissal under Rule 41, as courts have held, or can be enforced through early summary judgment, as both the Seventh Circuit and Third Circuit have held. Petitioner takes the extreme position that a federal court must ignore the entirety of a state statute if any part of it might conflict with a federal rule in some case. This court has rejected that approach, which is why petitioner in the briefing effectively concedes that to prevail, he has to convince the court to overrule at least 3 of its decisions: Cohen, Woods, and Gasparini. That intrusion on the jurisprudence of Hanna is both unnecessary and would interfere with federalism. I welcome the court's questions.
You raised, though, the affidavit of merit argument in your answer and not in a motion to dismiss. Could you have raised it under another federal rule of civil procedure?
In fact, we simply answered the complaint, Justice Thomas. We didn't claim that the pleadings could not be closed. What we did do is we filed a motion for in-camera review with the trial court, and then the case proceeded, the pleadings were closed, and the case, in fact, entered discovery. There are at least two ways you can raise an affidavit of merit requirement consistent with the federal rules. As I said, Rule 41, B, which allows for involuntary dismissals. If a plaintiff cannot comply with the court order, here the court did order petitioner to comply with the affidavit of merit requirement, or you can raise it through summary judgment. So either of those approaches are perfectly consistent with the federal rules and don't create any conflicts.
So, Mr. Yarger, suppose a state said, you know, this notice pleading stuff, we're really a little bit tired of it, and we want to go back to code pleading. And so we're going to enact a requirement, and it says, it's going to say for some category of suits, or for all suits, who knows, you have to do code pleading. We're not going to insist you do it in a complaint. You can just do it in a separate document. Call it an affidavit of merit. Call it a non-pleading if you want to, but it's got to be filed very early in the lawsuit. Would that be all right?
If it's an affidavit that's separate from the pleadings,
that's what we're calling it. We're calling it an affidavit of merit.
Of course, my position is you can enforce that. I think the question is...
So you can enforce that. I mean, that is like exactly what Rule 8 and indeed the entire structure of the federal rules was designed to prevent. If there was one thing that the federal rules did, it was to say notice pleading uniformly throughout the nation in federal courts.
And this is not a rule of pleading, which is our point. The pleadings itself.
But the hypothetical I'm giving you is all we do is call it something different, and we're back to a code pleading system.
Understood. And if that's the case, Your Honor, Erie, of course, is going to kick in. And that's the second step.
I don't know how we get, why do we have to get to Erie? I mean, it's just got to be the case under Hanna, et cetera, that you look at Rule 8, you look at Rule 9, you look at Rule 12, and the whole package of it says no code pleading in federal courts.
If it in fact conflicts with Rules 8, 9, and 12, which the affidavit requirement here does not.
Well, I guess the question is why it does not. Okay, I'll give you some more examples. Suppose there was a state that said too many darn contract suits, so we're going to make people come up with affidavits from an economist denoting all the different damages that apply. And we're going to do this also. You've got to do it within the first 10 days.
I think the key question in all of those cases, Your Honor, is how do the parties bring those issues to the trial court and present them through the rules of civil procedure? There are mechanisms.
Well, I guess what I'm suggesting is that you don't do that through the rules of civil procedure, because the rules of civil procedure, although they don't say you cannot apply additional requirements like that, the rules mean in the same way that they meant in Hannah, in the same way that they meant in Shady Grove, that no, if you try to impose requirements that make medical malpractice claims, contract claims, trade secret claims, on and on and on, if you make them subject to special requirements whereby the plaintiff has to come forward with some sort of proof that their claim is good before anything starts, that's inconsistent with the entire structure of the federal rules.
Sure. So a couple of responses. One, the affidavit here is a separate requirement apart from the proof and the evidence in the case.
I mean, we're going to label all of these affidavits. You have to file your trade secret. You have to file your economist's report. You have to file an affidavit if you're in a car accident from one of those accidentologists saying that the thing was your fault. It was the defendant's fault.
Sure.
I mean, every kind of suit has something that you have to prove, and we're going to make you file something before the suit gets started about why it is that you're going to be able to show in the end that you meet the elements of the suit.
And I bring up the fact that this is outside the evidence and outside the pleadings because it's much more like the bond requirement at issue in Cohen, which was a requirement that the state of New Jersey had placed on certain types of suits, derivative suits. And it could be raised at any time during the course of the proceedings. And if it was not satisfied, the case had to be dismissed. That's why petitioner wants the court to overrule Cohen, because it's a significant barrier that he has to affirming application of Delaware's affidavit of merit requirement in federal court. It's not part of the pleadings. It doesn't constrain the evidence in the case. The Delaware Supreme Court has said that very clearly. It's a separate requirement necessary to demonstrate that a plaintiff has done the appropriate consultation with a medical expert to say just what the statute says, which is that there's reasonable grounds to proceed. Our only point, and I think the only question under Hannah, and this is very important, is that if those requirements can be enforced in federal court using the federal rules without any conflict, there's no occasion for a federal court to disregard the requirement in all cases for all time forever in federal court, which really is petitioner's position. In Hannah, the conflict, Justice Kavanaugh, was unavoidable. That's what the conflict has to be. There was no way for the court not to adjudicate the conflict because the trial court had dismissed the case due to the method of service the plaintiff had decided to use. It was either apply the state rule of service or the federal rule. There was no choice between the two. Here, at no point did any party or the trial court attempt ever to do anything that created any kind of conflict with the federal rules, which is our point. And if Cohen can allow states to regulate causes of action for shareholder derivative suits, which are wholly within the state power to regulate, Delaware ought to be able, like most states, regulate medical negligence claims, which the parties agree are entirely within the power of state legislatures to regulate.